Welcome to another episode. We are talking about property disputes and resolutions. How do we fix these disputes? We have first of all, let me introduce myself. I'm Evan Saint-Gerard, Keller Williams Realty. You're a real estate agent in Queens, Long Island, Brooklyn, the Bronx, sometimes Staten Island. But anyway, my special guest today is Anthony Russo. He's an attorney, one of the best real estate attorneys that you'll ever find. And Anthony, say hello to the audience.
Hello, everyone. Thank you, Evans, for having me.
Anytime, anytime. So we're talking about property disputes and some resolutions, how we can fix some of these disputes. So where do you want to start?
Well, today, the biggest thing that we see in the real estate practice are boundary line disputes. Most people, when they have fences, they're not actually on the lines. Most fence companies put up a fence as close to the line as they can, or sometimes far off. But believe it or not, that becomes the biggest problem in closings today. Almost every file has that dispute. Queens, the five boroughs, less often. Long Island, Nassau, Suffolk, more often. It's just because the way the parcels are divided. But nonetheless, fence issues become huge obstacles in closing transactions.
So what's a way basically that we can fix these disputes?
Well, the first and simplest rule that I'll tell people now is, if you're ever going to put up a fence on your property, try to make sure that the installation goes properly, meaning the fence is actually put on your property line or over your line onto a neighboring property. So many of you may think that sounds alarming. I'm telling you to go over your property line, but legally or from a title insurance standpoint, which is our world when we're buying and selling property, the problem only arises when there is a fence that is short of your own property line by more than a foot. So if a fence is on the line or actually over the line, it does not create any obstacles for you to sell your property or for someone buying your property. And that's our goal, to sell or buy property. So on the line or over the line.
Could you repeat that one more time? Because I just want to make sure that nugget basically stays in people's heads.
Sure. The rule of thumb is if you actually put up a fence, you want the fence to be on your property line or over your property line so that it may encroach on your neighbor's property. That sounds incorrect, but believe it or not, that's the proper way for you to be able to avoid any issue when you sell your home. The issue arises when your own fences or someone else's fences are on top of your property, short of your property line, that cut you off of a portion of your own land. That's where the issue arises. So if you're going to put up a fence, put it up on the line or over the line.
All right. What are ways around? Let's say basically the property already has the fence is already there. Basically, what are ways of resolving the situation? I mean, what we've done. I don't know if you suggest. I think you do suggest this as well. Is pretty much you have a conversation with the neighbor. It's very simple.
It's critical. That's what it comes down to. There's a bunch of different solutions depending on the actual issue and how long it's been there. So all of this is based upon a law called adverse possession. Basically, if someone else is using your land, this is in summary, it's certainly not this easy. If someone else is adversely using your land, thinking it's theirs for more than 10 years, that land may become theirs. So if a neighbor of yours is using, let's say, 5 feet of your property and treats it as his own or her own, thinks it's theirs and does all these other steps, that land after 10 years could automatically be the neighbor's. So when you go to sell your property and you have a 50 by 100 lot, you may have lost 5 feet. And that 5 feet may not be relevant to you, but it may be relevant to the buyer. It definitely may be relevant to the bank or the title company insuring that buyer. And if that buyer wants to ever develop the property, change the property, add on to the property, put a pool in, that shortage may be crucial and they may not be able to do what they want to do. So the reasoning is that you need to know if this is an issue. Most times you won't know until you go to sell and someone looks at a survey or does a new survey and realizes that the fence is not on the proper line. And at that point, the only way to resolve it, which is what this whole conversation is about, is really having a good relationship with your neighbor to get it fixed. That fix becomes, again, several different options. The first is you can have the neighbor sign an affidavit that says they recognize it's not their land. That's helpful, but really doesn't cure the problem because an affidavit just sits with you or me and doesn't get recorded against the property. So there's no way to enforce that down the road. The proper way to do it is called a boundary line agreement. It's like a formal deed. It's almost saying, listen, if I lost these 5 feet to you, you're actually deeding it back to me. So you're releasing any claim you may even have to this property. And that boundary line agreement has to be prepared. It's a longer document. requires other forms that require social security numbers, which people are usually adverse to giving, but it's required. It's recorded with the city or the county. And then it, as a record, says that this extra strip of land is definitely ours to sell or yours, doesn't belong to the neighbor. And that's the real way to document this. But if you don't have good relationship with your neighbors, a lot of times they'll refuse to cooperate. And then the only way to resolve it is through litigation. Costly, time consuming, and will definitely slow down, if not stop, your sale or closing on this property.
I think you hit it on the head. You have to be nice to your neighbors. It's plain and simple. Wave good morning, say hello, how you doing, all that stuff, so you can avoid issues later on. If you're
Right.
sharing a driveway, good morning takes you a long way, as opposed to not saying good morning and cost you a lot of money
Yep.
in the future. So just be nice to your neighbors.
Yep.
With that being said, you had mentioned surveys. How often should people have surveys? I mean, let's say they bought the house 20, 30 years ago and they have an old survey and they've done work, obviously, within those years. Should they get a new survey, and how
Well,
often?
from a legal standpoint, I would not recommend that anyone who owns a home get a new survey. When they do work at times, certain types of work, the county or municipality may require a new survey to see the actual drawing of how everything lays out for different reasons. So if it's required by the municipality, then you have to do it. Makes sense. If you don't need one for any other particular reason, I would not advocate to pay for one or get one. When you go to sell, the buyer will ask if you have one. If you have one, you give it to them, or they'll look for one in the county records, and that will be used as a starting point by the buyer to see if there's any issues in the buyer and their title company. If one is needed for closing, the buyer is the one who will decide if they want one and go pay for one. And then that survey will reveal to the buyer and their title company if there is a boundary issue like we're discussing. So generally, I wouldn't advocate for a seller to get one unless they know they need it for a reason. If they wanted to head off a problem, you could pay for one, but the buyer generally will get their own, unless the seller needs it to clear an issue. So if I'm selling a house or my client's selling a house and I know I need a permit for a garage or something that I added on, that town's going to require that I get a survey. In that case, if it's in the middle of a transaction, we're in contract and we have to get a survey, a lot of times the buyer and seller will split the cost of that survey. One, the seller needs it to clear the issue, and two, the buyer needs it when they buy the property and get good title. So it's a shared expense in my contracts, at least if it's needed by the seller to legalize something.
All right. Again, communication is key.
Yes.
You have to communicate, basically, buyer, sell side. It doesn't have to be adversarial. It's
Yeah.
basically you have a common goal. You want to sell the property, you want to purchase that property. Let's work together and make this happen for everybody. The other thing I wanted to ask you is pretty much, do you see anything else that we haven't discussed that comes up a lot, basically, when it comes to disputes and how to fix them?
I mean, property disputes generally involve these boundaries, as I said. The other disputes that come up is if you're in contract and there's a problem, what happens with the down payment? That's the biggest type of dispute that I see. Generally, in a contract, I usually, I'll advocate, if I represent a buyer, to put down 5% of the purchase price as a down payment or less, whatever the seller will agree to. Some parties will ask for 10%. It used to be a pretty common practice, but given the prices of homes, 10% is a lot of money. So for 5% down, a buyer is committing a lot of money to make sure they go forward. The seller's attorney holds that money in an escrow account pending the closing. But if there a dispute arises, that seller is going to threaten to keep that money. There's protections in the contract, of course, depending on who reviewed the contract and protected the buyer. But those protections are there. But nonetheless, I'd rather have a dispute over 5% than 10% if I'm a buyer. So, a dispute could arise over anything. Inability to get the mortgage, getting the mortgage and the bank canceling, refusing to fund the loan. A seller or buyer may pass away, and does their family have to go forward with the deal? A lot of times legalization issues, C of O's, certificates of occupancy, violations, things like that, things that might have been added to the property and not legalized, and the time for the seller to do that, the expense for the seller to do that. Can the buyer wait? Will the buyer wait? And will the buyer's bank and will their interest rate locked remain? Because of all those timing problems that we're under today, a lot of times the buyer can't wait or won't wait, but the seller has the buyer's money and may not want to give it back, may want to hold the buyer to this deal. Maybe the market shifted and it's worth less, the property, and they don't want to start all over. So those are the types of instances where the down payment becomes a dispute. And again, we talked about this before, Evans. If you have, a real estate attorney representing you and he or she, protected you the best they can, you should have some adequate protection in that contract if these situations arise. If the attorney just let it go through the way it was and really didn't pay attention, then there might be other problems that arise out of those issues when a substantial amount of money, 5% or 10%, is on the line.
I'm going to keep saying this until people start quoting it back to me. It's very important who you use. Who you use matters. The other thing you did mention, could you briefly talk about CFOs?
Yeah, CFOs they're called certificates of occupancy, certificates of existing use. The way I talk about they're like permits. They basically, I shouldn't say permits because permits a first step in getting a CFO. But a certificate of occupancy means something is legal. So when a house is built, they issue a CFO, certificate of occupancy. The house can be occupied. You need that before you buy any house or you live in any house. As things get added to a house, they require other certificates, sometimes central air conditioning. If you add a dormer or extension, extra bathrooms, garage conversions, in some towns, central air conditioning, pools, decks over a certain height, gazebos. It could be multiple things that need approval by the town. A lot of people do work, don't want to pay extra taxes, which I understand. They'll do these things and not get it legalized. When the buyer comes to buy the property, they may like that feature of the home, but will their bank close on the property without a permit or CFO for that addition? More importantly, if the bank says no, but the buyer had agreed to take it that way, what happens to the buyer's down payment? The buyer says, yes, I'll take it with this deck, even though I know it's not legal, but the bank says, I can't lend to you with this illegal deck. Now the buyer has put down 5%, signed a contract saying, I'll take it with the deck as is, but the bank won't lend as is. So that's a huge predicament that, again, in my buyers, I protect them in the contract. Not everyone does, and that's a key risk factor. But certificates of occupancy are a common issue today because a lot of people have avoided getting them for different things or don't want to get them, and I understand that. But the bank's reaction to that and the buyer's protection, if something is missing, is critical to contract drafting and negotiation.
All right, I just wanted to go back a little bit. Some banks will close and they don't need a certificate of occupancy for certain things. So again, who you use matters. So pretty much some banks might be a little more flexible and some might be a little more strict. So it really is important basically who you're working with when it comes to that. And again, with every problem, there are many solutions.
Okay, yes, that is the case. So a lot of my business is, protecting my clients, but then when things come up, directing them with the proper solutions to get them through that legally and properly, of course. But that's the whole, the whole role, I think, as a real estate attorney is to guide my clients through that process, whether they're selling or buying.
I forgot to ask you this before. How many years in the business have you been?
32 years I'm doing this.
So that's 32 years of knowledge, experience, good relationships with realtors, with bankers, with other attorneys. That is very key. And that's something you definitely want to have on your side, basically, if you're looking for a real estate attorney.
Yeah.
With that being said, and this is my segue, how can they tap into your knowledge? How can they reach out to you, basically, if they want to pick your brain, or basically they want to hire you when they're ready to make a move with a buy or sell, or basically do both?
I appreciate that, Evan. And I must say that is, my expertise does help me in my practice, whether I'm dealing with other attorneys or navigating these issues that I'm, very familiar with. So it definitely makes it easier for me and a benefit to my clients. But I can be reached anytime. My office number is 516-746-7371. My cell phone, which I give out to all clients, realtors, is 516-312-7249. And I can be reached by email, awrusso@awrussolaw.com. I have a paralegal who's been with me for 20 years. He's a valuable resource to me and my clients when I'm on the road. So we have a nice team approach, and working with other experts, realtors, Evans like yourself makes it a pleasure to do this business. So really, I'd be glad to help anyone. Any questions or concerns, be glad to assist if I can.
All right, you know what's coming up next. Who you work with matters. So if you want to buy, sell, or invest in real estate, feel free to give me a call. Even if you don't choose me, you need some advice, I'm happy to help, point you in the right direction. My number is 917-975-5985. You can also find me on social media, which TikTok, Facebook, Instagram, LinkedIn. You find me everywhere. Just look up my name, my full name, Evan Saint-Gerard. And our website is also mynyhomesales.com. We will answer your questions. If we can't get that answer, we will definitely reach out to Anthony basically and see if we can get those answers for you. And like I said, basically who you work with really does matter. So pick wisely. This is a big thing that you're doing. I commend you basically for doing this now. If you're buying or selling or doing both, but always choose wisely and always ask for recommendations. So if you have a realtor, ask for a real estate attorney recommendation, or you have a real estate attorney, basically you need a good realtor, ask for a recommendation. Do your research, and whoever you're picking, basically they will be able to provide you with, hey, here's a list of some of my clients, recent clients. You can give them a call. I do that. My team does that a lot. I'm pretty sure Anthony basically has a lot of clients basically that can vouch for him as well. So you don't have to take our word for it. You can always reach out to other people who use them as well. With that being said, I know I said a lot. It's a mouthful. Anthony, you got the last words. What do you want to tell the audience?
Listen, every contract to buy or sell property contains risk. You need experts to help you navigate that risk and minimize that risk, and that's what we're here for. So I appreciate the opportunity to speak. And as I said, reach out if I could help in any way.